Premises liability refers to the area of the law where the courts determine who is liable when someone is injured on another person's property. If you own a business, Texas law imposes a duty on you to make your premises safe for people who are visiting. The nature of that duty depends on the specific status of the person on your property. The highest duty is owed to an invitee, someone that's invited to be on your property. That doesn't mean you have to have invited that specific person by name. Instead, what matters is if you hold your establishment out for a specific group of people, then they're invitees. If you sell a product or service and someone walks in to buy that product or service, they're an invitee. Premises owners have a duty to protect invitees from an unreasonable risk of harm that the owner either knew or should have known about by warning the invitees and making that condition safe. If your store is open for business and there's a large patch of ice on the front steps that isn't clearly visible, you've got to take steps to warn customers and address that danger. If you don't and your customer slips and falls, you're potentially liable. And that's true whether you actually know about that ice or only if you should have known. So, if you know that temperatures are freezing and there's been precipitation, as a store owner, do you have a duty to know if your entrance is safe? Probably so. A slightly lower duty applies to licensees. A licensee is different from an invitee in that a licensee isn't specifically intended to be in your establishment. So, if a salesperson comes calling on you, they're probably a licensee. The duty owed to a licensee is almost the same as the duty owed to an invitee, with one key exception. You only have a duty to warn a licensee of an unreasonable risk of harm based on something you actually know about. So if someone spills a soft drink in your store and a door-to-door salesman falls on it, you're probably not going to be liable if you didn't have actual awareness of that spill. The third category is a trespasser. A business owner owes almost no duty to a trespasser. If a burglar breaks into your store and injures himself, you probably aren't going to be liable unless you were grossly negligent in creating a very dangerous condition. A special category to be aware of is contractors and their employees. One of the most common times for someone to be injured at a business is when a contractor is doing work there. A contractor is usually an invitee. You need to inform them of dangerous conditions that you are or should be aware of. But if that contractor or their employees are injured in the performance of their work, the premises owner is protected from liability so long as they are not exercising control over the manner in which the contractor performed their work.